Let me make sure we have everybody we need. We're on the record at 231-500-139. State of Utah versus Kouri Richins. Can I have counsel for the state make their appearances, please?
Good afternoon, Your Honor. Brad Bloodworth, Lindsay Shervanack, and Fred Burmester for the state.
And, oh, Ms. Nestor is caught on the attendees list. One moment. Okay, my apologies. Counsel for Ms. Richins, please. Oh, you are muted. Let's fix that.
All right, thank you. Wendy Lewis, Catherine Nestor, and Alexander Ramos for Ms. Richins. And I believe she's present on WebEx.
And let me just confirm. Ms. Richins, can you just confirm that you can hear us okay? Give me a thumbs up if you can hear okay. All right, very good. You're welcome to turn your video off if you prefer. I'm going to mute your connection just so we don't pick up any unintended background noise. All right, counsel, we've got several scheduling issues to discuss. First, Mr. Bloodworth, I think it would be helpful for the state to file an amended information that reflects the dismissal of what was previously numbered as counts 3 and 4, and the severance of what was previously numbered counts 5, 6, 9, and 10. Any objection?
No objection, Your Honor. We can do that too. We can also probably address the redundant charging between the information on the aggravated murder and the recently filed information involving some fraud as well.
Okay. And is that something that you address through? Well, let me take a step back for a moment. My apologies. My anticipation was that contemporaneous with that amendment, a new information reflecting 2 counts of mortgage fraud, 2 counts of forgery from June and August of 2021 would be filed, and that court staff would backdate that information to match whenever those counts were originally filed in this case number. Do you see it differently?
Your Honor, I apologize. I'm not following.
So as it sits today, the most recently filed information in this case has 11 counts in it. 2 were dismissed without prejudice on November 12, 2024. Yes. And on the same day, the court made some rulings regarding joinder and by implication severance. And those rulings separated, for the purpose of the upcoming trial, counts 5, 6, 9, and 10, which are mortgage fraud and forgery based upon events alleged to have occurred in June of August in 2021. Those counts need to be severed from the operative information in this case. But the filing date needs to be backdated so that there's no statute of limitations problem.
I understand, Your Honor. Those counts, 5, 6, 9, and 10, are also included in the recently filed information involving Ms. Richins and some other fraud counts as well. So the state will, in essence, dismiss them from the current information because they are charged in the new information.
Now I understand. My apologies. Okay. The newest filed case, criminal case against Ms. Richins, I have not seen a summons and I have not seen a warrant. What is the intent on that case?
Your Honor, summons, and I apologize. I thought it was in the information. We can fix that.
Okay.
But it is summons. The state had figured the court would, based upon summons, I guess, conduct an initial appearance and appoint counsel today. But if we can get a summons and do that next week.
Ms. Lewis, have you and Ms. Nestor and Mr. Ramos had a conversation with Ms. Richins about whether you'll be appearing on her behalf in that new case?
Well, we'd have to be asked by the county to do that, and nobody has asked us to do it yet, so we didn't know what was going to happen with that. We're willing to do it, but
Yeah,
typically Jenny Young reaches out to me if she wants us appointed or me appointed on something, and that hasn't happened.
I know it is. We have conflict counsel now. I don't know if the contract has changed. No, but the prior contract didn't include capital charges. Folks, this is not something I'm supposed to be getting involved in. I'll reach out. I'll ask Brittany to reach out to understand what the current contract with conflict counsel looks like as it relates to the charges that are in the most recently filed information, and hopefully Ms. Young can provide some clarity. Okay.
Your
Bottom
Honor,
line, Mr. Bloodworth, I don't have a summons yet, so I'm not in a position to hold an initial appearance.
I understand that, Your Honor. We'll address appointment of counsel, I guess, once the court holds an initial appearance. But to preview matters, it's the state's view that it would make sense to appoint Ms. Richins' current defense team, considering the overlap in discovery and information, that kind of thing.
Okay. Perhaps someone from your office can transmit that view to Ms. Young.
Yes, Your Honor, we can probably do that. We try to stay out, as you can imagine. We try to stay out of the appointment of counsel business as well.
Yeah. Okay. We'll take this one step at a time. In case ending 139, if the state would please file an amended information that includes only counts 1, 2, 7, 8, and 11 as the counts going to trial in February.
Yes, sir.
Okay. Ms. Lewis, anything further on that?
No, Your Honor.
All right. I circulated today a copy of the juror questionnaire that we had previously sent to potential jurors in March. If you all would re-review it, compare notes, and then let the court know whether you propose any changes to it. Can you send me, though, a response on that issue by September 5, Ms. Lewis?
Yes, that'll be fine.
Mr. Bloodworth?
Yes, sir.
All right. Ms. Shervanack, are you handling that issue again?
Probably.
Okay, September
Yep.
5. All right. You can do it by email, or you can file stipulated something or competing somethings. I just need to get those to the jury team so they can start getting ready. Okay. Anything further on that, Ms. Lewis?
No, nothing from us.
Ms. Shervanack?
No.
Okay. One moment, folks. Just to review and make sure that we don't need to make any changes, we'll send the questionnaire to 2,000 Summit County jurors. Council will receive the completed questionnaires, as many as we get back, by. Okay. Anything further on that, Ms. Lewis?
No, nothing from us.
Ms. Shervanack?
No.
Okay. One moment, folks. Just to review and make sure that we don't need to make any changes, we'll send the questionnaire to 2,000 Summit County jurors. Council will receive the completed questionnaires, as many as we get back, by January 20. February 2nd, 9:30 a.m. in person, we'll hold a hearing to strike jurors for cause based on questionnaire responses and council's review of questionnaires. And then we are scheduled for attorney-conducted voir dire over up to 6 days, February 10 to 13 and February 17 to 18. 2 sessions each day, 8:30 a.m. to noon and 1 p.m. to 4:30 p.m. each day. It will be 20 jurors in the morning, 20 jurors summoned for each afternoon, and it takes as long as it takes to pass 24 jurors for cause. Ms. Chervenak, you're furrowing your brow.
Why 24?
It's a jury of 8 plus 4 alternates by previous stipulation, and then 8 peremptories per side.
Oh, I see.
No,
Clear.
sorry, 8 peremptories total.
You're talking about having to clear. I see. I thought you were talking about seating 24.
No. Sorry, 24 passed for
I just
cause.
misheard you.
And I want to make sure I didn't, 8 jurors plus 4 alternates plus 8 peremptories per total for a felony case plus 2 additional per side, given the additional alternates.
Yep.
Okay. Ms. Lewis, any comment on that?
Not at this time. No.
Okay. All right. Then I listened to the last pretrial conference that we had in June. I asked counsel to meet and confer regarding some potential hearing dates to hear motions that have already been filed, including an evidentiary hearing on defendant's motion to exclude state's expert witnesses, which is fully briefed. And then also to come up with some filing deadlines and a potential hearing date for the forthcoming defendant's motions in limine, which Ms. Nestor previously described as substantial. So what have you all come up with?
The state has said whatever we said is fine with them. So we didn't really come up with anything specific, but how far in advance do you want to set these? I mean, we can just get them set now.
All right, let's do this one at a time. The evidentiary hearing on defendant's motion to exclude the state's expert witnesses. Is that half a day? Is it a day?
I would think we could do it in a half a day. I don't know. Do you disagree, Kathy?
I think it's
Or
gonna
Brad?
take a day. I think
You
it's
think
gonna
we
take
need a day?
I agree. It's a day. It'll be two
All right.
experts. I think a half day apiece.
And Mr. Bloodworth, I recall asking this, but I can't recall the answer. It's 2 experts that have been challenged, the profiling expert and the domestic violence expert. Is that correct?
Correct.
Correct.
Handwriting expert.
And Mr. Mr. Throckmorton. Okay, so 3 experts: profiling, domestic violence, handwriting. Mr. Throckmorton has produced a written report. Is that correct?
That is correct, Your Honor.
The domestic violence expert, has that person produced a written report setting forth their opinions, or is it a summary that's been provided by the state?
Your Honor, the state's provided a summary, a proffer of their testimony.
Okay. And then the same question regarding the profiler.
The state's provided a summary of their testimony, again, a proffer.
Okay. All right. And forgive me, did those 3 productions include the CV for each expert?
Yes, Your Honor, it did.
Okay. All right. So we're talking about 3 experts over the course of a full day. Is that right?
Yes.
Yes.
Okay. All right. Counsel, let me ask a categorical question. Do you feel like we need to handle any of these issues prior to January, or can I just plan to spend a lot of time on this case in January?
I don't think we need it before January, Your Honor.
Mr. Bloodworth?
Your Honor, I think early January would work.
Okay. All right, let's begin with this expert witness issue. Ms. Lewis, Ms. Nestor, during the week of January 5, are there days that are preferable?
Kathy, I'm open that whole week. Alex, what do you guys have?
If we could avoid Friday the 9th, that would be great. But other than that, I'm open the whole week.
Okay. I don't think we have a calendar.
2026 calendar.
I know we don't have it. I don't think we have a calendar on the 9th, but that's irrelevant.
So maybe the 6th or the 7th, since that will have been right after the holiday weekend, maybe avoid the horrible Monday and do it like Tuesday or Wednesday or Thursday.
Well, and then tell me, should we block 2 days in a row? Should we do the expert issues one day and then hear oral argument on the walk the dog letter, the 404B evidence, and defendant's motions in limine on the second day?
I don't know that we may not be ready to do our motions in limine yet. Oh, yes,
Okay.
we will. Yes, we will. Yes, we will. By January, yes, we will. Yes, we will.
Is that enough time if I put all that stuff together?
Uh-huh. Yes.
Okay. Mr. Bloodworth, any objection?
No, Your Honor.
So may we block January 7 and 8 for those purposes?
So we're doing 7, 8, not 6, 7. Right?
Yeah.
Okay.
I'm going to need the 5th and 6th to get ready.
Yep.
That works for the defense. Your Honor, I just want to make sure I'm clear though, since that's a full month prior to trial, if something should come up between then and trial, I just want to make sure that I still could file a last minute motion in limine if I need to. But I mean, a vast majority, I will know by then, no problem.
I understand. I think Mr. Bloodworth is likely to ask for the same reasonable accommodation for his team.
Great.
Yes, sir.
Okay, let's block January 7 and 8 for in-person hearings on the following. On January 7, we will handle defendant's motion to exclude state's expert witnesses. That's docket 883. Let's begin at 9:30 a.m. that day. Then, state's a motion to determine admissibility of the walk the dog letter, which is docket 913. State's first notice of intent to offer for Rule 404B evidence, docket 865. And then defendants' forthcoming motions in limine will be addressed on January 8, beginning at 9:30 a.m.
Thank you, Your Honor.
Ms. Go ahead. I'm sorry, Mr. Blubber.
The state will, well in advance of them, file its second 404B disclosure. I suspect we'll want to address both at that time.
What's a reasonable filing deadline for the second one?
Your Honor, how about a month out? So whatever, December 8th?
September 5?
I didn't know if you meant a month out
A
from.
month-
Oh, I'm sorry, a month back. You
month
will,
out from
yeah,
the
that'll
beginning.
have defense counsel briefing during the holidays and maybe you all as well. Let's avoid. Can we do a little earlier than that? Can we say 6 weeks?
Yes, sir.
All right, so let me look at my calendar for a moment. Yeah, why don't we say November 26th?
Yes, sir.
And then Ms. Nestor, Ms. Lewis, can we agree defendant's response to the second notice is December 12 reasonable?
It's fine.
Yes, sir.
Okay. And then to the extent the state wants to file a reply regarding the second notice, let's just say January 31.
You mean December
mean that,
31?
December.
I meant December 31.
December 31?
My apologies. December 31. All right. Okay. Ms. Nestor, we need to come up with some similar deadlines related to defendant's forthcoming motions in limine. What sounds reasonable?
Do you want us to just follow that same briefing schedule? I mean, that'd make it simpler.
We can. Works for me if it works for you.
It does.
Mr. Bloodworth?
That works, Your Honor.
Okay. So the deadline for defendant's forthcoming motions in limine is November 26. State's response deadline is December 12. The defendant's deadline to file a reply, if any, is December 31.
And then, Your Honor, the state may have some motions in limine as well. We'll follow rather the same schedule.
Okay, very good. Okay. All right.
I mean, just to keep, not to beat the dead horse, but I think our exhibit and witness list would be due like 30 days before trial, which would be after my motion in limine filing deadline. So obviously if they file exhibits I'm not expecting, I mean, we'll just file them as soon as we are aware.
Haven't we seen exhibit and witness lists already?
No.
We've seen a
Did we just-
preliminary witness list, but no exhibit list, and the witness list was very preliminary.
We gave some
Right, the
witness
only
lists
thing we
with the
saw was,
questionnaire,
right,
but we haven't filed our formal disclosures.
Understood. Why don't we just set a much earlier deadline? Wouldn't you rather see that before you're filing motions in limine?
no.
Yes, well,
I don't
Well,
know. Can I see theirs and not show them
that's what
mine?
I was gonna say. We'd like theirs, but we don't want to file ours yet.
I wanted the latest possible date to file my witness list, please. But exhibit list, I don't mind doing in advance, I guess. I don't know. I'd like
don't
a
know,
late
I'm-
date on that too.
I guess we should think about that.
Okay. Mr. Bloodworth, I have a sense that you have a pretty good idea of who is on your will call and may call list and what's on your exhibit list. Is it possible for the state to file a list of will call and may call witnesses and your exhibit list? Bear with me. By October 31.
Your Honor, it is possible, but these filings are designed to be reciprocal.
Well, only one of you has the burden of proof, though. And so I imagine who they're calling is going to matter depending on who's on yours and what's on yours. And the burden's not reciprocal. And so I think there's some value in staging them here, given the briefing deadlines.
If the court orders it, the state will comply.
I think this would help move things along efficiently. Yeah, so October 31, states will call, may call witness lists and exhibit lists, understanding that in the run-up to trial, amendments happen. Now, Ms. Nestor, you're going to have to commit to a deadline of some kind. What's reasonable?
February 20th?
Well, I think the rules provide for 30 days prior. So if we want to do it, 45 or 60 days prior, I guess, but
I think the rule is 14 days.
Yeah, I think that's right.
well, then 14 days, that works out great.
Oh, hold on.
I'm thinking of federal court. I'm sorry. It is 30 in federal.
February 6th.
Okay.
Yep. Yeah.
Thank you.
Let me write that down.
And obviously, we are not producing on our exhibit list anything we're going to use solely for impeachment, only what we're introducing in our case in chief.
I think the state's probably applying the same rule.
Yeah.
Okay. One moment. All right, let's talk about jury instructions for a second. I previously stated on the record that I didn't expect the jury instructions in this case to be particularly complicated, but I may regret that. And so let's come up with a reasonable deadline for you folks to meet and confer regarding proposed jury instructions, and then to file whatever you can stipulate to, and then your requested additional instructions that are not stipulated. We don't have to have that nailed down at the start of the trial. I don't have to have decided what the jury instructions are going to look like at opening statements unless there's a particular instruction you want to discuss in your opening. But I need to force you all to begin that discussion prior to the commencement of trial. Ms. Nestor, what sounds reasonable?
Well, if maybe we could do it before that 7th and 8th, so that if we spot that we have a big issue, we could just lump it into that discussion with you.
That's fine. So here, let's do Did I really know? Okay. Ms. Shervanek, are you going to be in charge of jury instructions?
Your Honor, I'll probably handle that.
Forgive me, folks, for a little inside baseball here. Mr. Bloodworth, are you trying the Patterson case, or is Ms. Shervanek trying it?
Your Honor, that may be me or Mr. Hill.
All right, so I just need to make sure that I don't double book you here. Mr. Bloodworth, what is a reasonable deadline for the state to send its proposed jury instructions? Don't worry about opening instructions. I just need elements, evidentiary instructions, the things that would typically be in the closing instructions to the defense.
Your Honor, we can do that late September.
Okay. If you would send your proposal to defense counsel by September 26.
October, sir?
No, I think
Or September?
20.
I'm sorry,
Yeah,
September 26th. Gotcha.
is a Friday. If you would send to defense counsel state's proposed jury instructions, and then Ms. Nestor, Ms. Lewis, Mr. Ramos, how about October 31 for defense counsel to respond to those proposals with, we stipulate to this instruction or we don't, and here are some additional instructions that we propose.
Okay.
Like the motions in limine, like the witness and exhibit lists, I understand that the exigencies of trial may require the proposal of additional instructions as trial progresses, but to the extent we can do some of this heavy lifting early, it will inure to the benefit of all of us. All right. Brittany, did you get those two? Okay. No, I'm going to end up doing it live. Okay. Aside from another pretrial conference, that's everything I had on my list. Mr. Bloodworth, did you have anything else you need to discuss today?
Your Honor, not on this case. We did file the summons in the new case while we've been talking. So if the court wanted to schedule an initial appearance now, if the court's inclined to appoint named defense team.
I mean, there is a statute that talks about whom I can appoint, and it requires me to have information regarding what the terms of the contract with the current roster of conflict counsel is. So I need to build in some time to get that response from Ms. Young.
Understand, Your Honor.
Yeah. If you all would like me to put an initial appearance on the calendar, I can. I can just put it out a couple, 3-4 weeks while we figure that out.
I think we should wait until we know what's going on, Your
So too.
Honor.
Okay, very good. We'll get that information, Ms. Young, figure out what I have the authority to do, and then we'll see what happens. Okay, Mr. Bloodworth, I interrupted you. Anything else?
No, Your Honor, thank you.
Ms. Shervanek,
No.
Mr. Burmester.
No, Your Honor.
Okay. Ms. Lewis, anything else the defense wanted to discuss?
No, Your Honor.
Well, Alex,
Oh, Alex.
I'm
did you-
sorry. Mr. Ramos.
There's two issues that I saw come up as we were preparing for the last trial, and it's more of a practical issue that obviously didn't come to fruition because of the trial date cancellation. But as we were leading up to trial, discovery was continuously produced, and we understand that's something. We also understand that the facts of this case are, in a sense, very much in a silo. We have continued to get discovery, and if that's going to continue to happen, we'd like to request some sort of deadline. Preparing for a case like this, Judge, if it was just the murder case would be one thing. Now with, just with the fraud elements of it, it is getting extremely messy. It's extremely difficult to see what's new, what's not. So I would like to try to find a way where we can limit that, one. And then the second thing, which is related, Judge, is in terms of the witnesses for the state, the exhibits, one thing that I think would be beneficial and really speed things up is, of course, we get an idea of who they're going to call and maybe what they're going to ask. But certainly having summaries of, hey, witness one is going to testify to, X, Y, and Z, and these A through G exhibits are tied to them to that, would be extremely helpful. Otherwise, what I fear is we're going to show up and there's like 40 plus witnesses and we're like, well, yeah, we have the discovery, we know what they said, but had we had some of it, maybe we don't even ask any questions, right? So it's more of trying to streamline the process, Judge. Those are just two things that came up, and I am very concerned that it's going to get worse.
can I jump on to the back of what Alex just said? I thought he said it very well. But I'm not even sure the court is aware of this, but we're at 10 terabytes of discovery in this case. It is the largest amount of discovery I've ever had in any case, and I have done complex fraud. They've gone back and found every human being that's ever spoken to Kouri Richins, ever. So the concern is, for example, if they're planning on calling like 15 witnesses that are just to create foundations for pictures, we don't even need them to testify. Like, we'll just agree these pictures are pictures of what the house looked like, or what, her childhood home looked like, or whatever the heck they're going to put in, and save potentially days and days and days of trial. So we're not doing it to add to their workload unnecessarily. We really are trying to determine, are there witnesses that are being called solely for foundation that we can say, hey, you don't need to do that. If you're calling them to put in, bank records, we agree to the bank records, cancel one less witness. This case has become ridiculous in terms of the amount of evidence. And when I say evidence, I don't mean anything that has anything to do with whether she killed her husband or not. I'm talking about just the universe of prosecuting Kouri Richins has become outrageous. So I guess I don't want it to sound like we're trying to make them give us an unfair advantage. We're trying to eliminate days and days of unnecessary, pointless trial days. So I just wanted to add that to what Alex had to say.
So let's break this down a little bit. With respect to a deadline by which the drawbridge will be raised and the information inside the Discovery Castle here will be set, Mr. Bloodworth. I can appreciate why there may have been rolling productions in the past as additional forensic downloads or analysis of electronically stored information occurred, but we should be beyond that point now. Have we produced the discovery that is in the state's possession or control?
Yeah.
Okay. And aside from some kind of realization that something got left out, analysis has, at least searches and analysis are concluded. The universe has been produced.
It's hard to say, Your Honor. As it relates to some of the 404B evidence, perhaps not. As it relates to some of the more core evidence, if the court will, then I believe it has. You know, we could always find some additional information, but I'm not anticipating that.
All right.
I think the question you need to ask is, are you still issuing subpoenas? Because as recently as 2 months ago, they're issuing subpoenas to try to find new evidence. I mean, it's off the chart.
But I'm not sure that's unlawful or against the rules, Ms. Nestor.
No.
Here, I need to make sure I keep it fair in terms of making sure that you get fair disclosure of discovery and, of course, potentially exculpatory information under Rule 16. And I hear you, Mr. Ramos, like at some point, we need to know what the universe is so we can prepare. So let me fast forward for a moment. Hold on a second. I apologize for cutting you off. Let me at least let you know where I'm headed, and then you can tell me why it may or may not work. I've set a pretty early witness list and exhibit list deadline of October 31. That would seem to be, starting November 1, an opportune time to actually sit down with counsel for the state in the fashion that I asked you to do before today, but which sounds like didn't actually happen. And go through the exhibit list and say, we'll stipulate to authenticity and foundation for all of these exhibits. So to the extent you're calling witnesses to say the Rule 90 whatever foundation for these exhibits, you don't need to. We'll stipulate that those are authentic, and we're just going to reserve our relevant or cumulative or unnecessary objections for trial. That would seem to be a way to start cutting through this. No?
Right, but if they have like 10,000 new documents they give us in the month before trial, how are we ever going to have time to do that?
Well, that would be different. And if that actually occurs, I think you would have some arguments to make about this is unfair, Judge. You can't let him do this. But that's different than me creating a standard where they have to summarize the expected testimony of their witnesses. I'm looking at Rule 16A5. It doesn't call for that.
It doesn't.
But I can make you talk to each other.
Well, what could we go back to the idea of closing the drawbridge at some point so that we like can focus on, I mean, if their theory of the case keeps changing, I mean, at some point we have to know what their theory of the case is, right?
Well, I think you're going to know more than you do now, and with some clarity that you haven't yet had by October 31st.
Okay.
And so any objection to a court order saying that you need to meet and confer with counsel for the state to talk about exactly the kind of stipulations and streamlining that you described during the month of November.
I don't think you need to order it. I think we're going to end up doing it anyway. I mean, that's our whole goal,
In
right?
fairness, I ordered you to contact them regarding deadlines for hearings and filings, and you didn't do it.
Oh,
And
we
so
did.
I think
No, we
maybe
did.
a gentle nudge.
We did contact them and they said any date was fine with them. They had no preference at all.
Let's be a little bit more detail oriented. I need you to sit down with them and go through their witness and exhibit lists and have a conversation about, all right, is that person just laying foundation for exhibits? Or how about we talk about these exhibits? We think we can stipulate to the authenticity and foundation for this list. Does that reduce the witness list at all? Just have a conversation.
We're happy to do that. I mean, we're planning on doing that anyway. That's why we wanted that early release date of the exhibits.
So during the month of November, yes?
Sure.
Mr. Ramos, is that possible?
No, it's not. That's not
Okay.
a problem. I guess one of my concerns is when we're talking about 10 terabytes of discovery, and within that discovery, there's also duplicates, right? And it is not, it's organized. It's not organized in a efficient manner. And
Why don't you vertically and horizontally deduplicate it?
Yeah, it's harder than you think to do that.
well, I mean, two
You
things.
may need an e-discovery vendor to do it, but
Well,
they would be able to horizontally and vertically deduplicate the documents so you don't have 12 copies of the same email.
We understand that, Judge, and we've started our own process. My point is this, that there is no reason why from the beginning there should be duplicates or triplicates of the documents, right? And as we get more documents that are being put in there and not organized in a certain way, it also does mess with the way that we're going about it, right? So the only thing that I guess that we're trying to make sure, we understand there's going to be rolling discovery in all cases. We're trying to find a way where we can get to a point where it's at least manageable, where you mentioned the word universe. Right now, there's some black holes in that universe that we're just completely lost at times, right? And it has to do with a variety of things. I think the October deadline is going to be great. We do want to bring this to your honor's attention now. I do not see a reason why this continues, even these subpoenas 2 months after, even the trial was canceled. Regardless, though, we're bringing it up now so that we're all on the same page. We'll be ready. We're just trying to be as efficient as possible when it comes to the actual trial deadline, because using your castle analogy, there might be some witnesses up there that are nothing more than jesters, and we're just sitting there. We don't want to do that.
Well,
So, yeah.
all right, let's take a step back. The rules of evidence still apply. And so if there is testimony that's simply not relevant or is it unnecessarily cumulative, it gets excluded. So you always have that tool. Second, to the extent there are black holes in the discovery, pick up the phone and be like, I don't understand where this big gap is. Third, I understand your concern regarding getting served with another terabyte of seemingly duplicate information, but a lot of that information probably has metadata. And I would understand why the state wouldn't start excluding things that it thinks are duplicates and risk not producing potentially relevant metadata. The better rule for prosecutors is to overproduce, to avoid any potential Brady issues. And so I think we're just going to have to work through this by counsel meeting and conferring a number of times. I simply don't have enough information to fashion any sort of remedy sitting here today. I appreciate being made aware of this. We'll take it one step at a time.
Well, I think we realize we don't have a remedy, which is why we're just making your honor aware of it.
Okay. I'm sincere when I say, please pick up the phone and start talking about these issues. Prior to taking the bench, I did a lot of complex litigation with a lot of financial information and e-discovery issues. And since taking the bench through things like the consolidated opioid litigation, we've had to manage the same things. These are not unique issues. They just take time and effort.
I'll bite my tongue, Judge. Fair.
Okay. I cut you off there, Mr. Ramos. My apologies. Anything else?
No. Thank you.
Okay. All right.
Your Honor, there is one matter that I think is still waiting on a ruling that I haven't heard you refer to. I just want to make sure we don't lose it. So
No, I've got it. I owe you an updated ruling regarding defendant's motion to compel disclosure of Giglio material, docket 818.
Correct. Thank you, Your Honor.
It's on the list.
Thank you.
Okay. Counsel, does it make sense to set a pretrial conference sometime during the month of November to check back in regarding some of these issues that Mr. Ramos has raised the court's awareness to?
Sure.
Okay. There are a sufficient number of nodding heads that's what we're going to do.
So Ms. Ms. Lewis and I have a trial that is likely to go the week of November 17th. So if we could avoid that week, I would be grateful.
No, we got to stay away from Thanksgiving too.
Yeah, so maybe the week of the 10th.
We can. Do you want to be doing this the week before that trial, or would you prefer to go to, say, December 5?
December 5.
We can do that.
December 5th works for me.
Mr. Bloodworth? Okay, counsel, 3:30 p.m., December 5 for a pretrial conference. Happy to do it by WebEx, if that's helpful. Ms. Lewis?
That would be fine. Yeah, let's do it by WebEx.
Okay. And Ms. Lewis, are you comfortable with Ms. Richins appearing by WebEx?
We are.
Okay.
Can I
December
just-
5. Oh, I'm sorry. Go ahead.
I'm sorry, I'm backtracking here. In terms of the discovery issue, and maybe I could just throw this out here so we're talking about it. I think a lot of the problem here is that Box isn't really equipped to handle this type of discovery. It's really difficult. I mean, the Box is great in a normal case, but in this case, it's awful. I can't find hardly anything in there. You made the point, that's what I was thinking about earlier about, having someone organize this, getting a professional to organize the discovery. But on the defense side, our budget is very limited. I don't think we'd even be allowed to do that at this point, and that's going to be expensive. So I don't know if we just want to throw out there if it's something the state could look into, some way to get this organized. I have some real concerns that something is going to come up at trial that's buried in there, and none of us will have ever seen it, just because, and we're really more like at 11 terabytes at this point. We were at 10 when we took the case a year ago. We're at about 11 plus now. So anyway, I just thought that might be worth throwing out there. I don't know if that's a possibility.
Your Honor, let me
I don't
make
want
a.
Yeah, I don't want to open a new can of worms here, though. But give me a sense for a moment. Is this 11 terabytes of PDFs? Is it a mix of file formats? Mr. Bloodworth, help me understand. Okay.
Your Honor, it's a mix. I don't know the number. I'm not disagreeing with the 11 terabyte number, but it's a mix of data formats. As the court is aware, the state shares discovery with the defense through Box. They see the exact same thing the state sees. We give them access to the Box folder that we create with all the discovery. We are both working from the exact same Box database. The
Okay.
defense has asked, because of their difficulty in employing Box. They have asked for the data to be provided on hard drives as well. So the state has done that as an accommodation. What they do with those hard drives, whether they get a vendor separate from Box to organize the material, the state has we have no say in that regard. They can do it. The state doesn't control their budget. I don't even know if they've asked.
Well, I think
for
the
money
state
to
does
do
control
that.
our budget, but maybe not
Well,
you,
I think
Brad,
he
but
means the Summit County Attorney's Office, and they don't.
And
Brad
I,
doesn't control our
I
budget as
don't,
far as I know.
I don't, as far as I know, they could be using the identical box we use. They could be using the data in a different, with a different vendor. They could have asked for money. They could have chosen not to ask for money. I don't know,
Yeah.
but we turn over everything we have in the same format
Right.
that we view it.
Let's pause for a moment. We have time to have reasonable conversations about this. Now, part of this will be, if not simplified, at least focused when the state makes decisions about its exhibit list. And that exhibit list is going to have to be sufficiently detailed to allow defense counsel to understand what exactly Exhibit 42 is and where to find it.
We've prepared a near final version of the exhibit list. It identifies documents by Bates numbers, and then we have created a separate folder in Box organized by Bates number of every single document we intend to use as an exhibit.
And has that been shared with defense counsel to date?
Not yet.
That will be once we finalize the exhibit list and turn it over on October 31st.
Hold
Sorry,
on.
Brad.
Everybody pause. Mr. Bloodworth, understanding that whatever the working version is not the final version. Is there any reason you can't share what you've identified and separated to date to at least allow them to start working?
Your Honor, they've had this material since the moment they came on the case.
I asked a yes or no question about a folder that they don't currently have access to.
They have been able to have worked. There's
know.
nothing we're
I
doing is
asked a
stopping
yes or
them
no
from working.
question about the folder that they don't yet have access to.
We could
Is there any
populate.
reason that it would be unfair to say, well, listen, we know, or sitting here today, we currently think we're going to use these. This case was set for trial months ago. Why can't we just give them access to what you've identified so far, understanding that you have between now and October 31 to change your mind, to add stuff, take stuff out?
Your Honor, we could probably do that. It would take some work assembling it, but we could do that before October 31st for sure.
Perhaps I misunderstood. And so I'm not trying to create a folder that doesn't presently exist. I thought I heard you say there presently is a working version of a box folder that has separately identified exhibits that the state presently intends to include on its exhibit list.
That is correct. There's a working version. We are trying to populate that box folder.
Okay.
As we're building out our exhibit list.
So by August 15, send them a draft or access to a draft of the folder. Understanding it's not going to be complete, it's not going to be final, and it does not prejudice the state's rights to add or withdraw exhibits from it in any way.
Understood.
Mr. Ramos, then you and the state will be in the exact same position.
And I will commit that if we know immediately that there's documents in there, we are not going to challenge authenticity. I promise we will let him know very quickly so he doesn't even have to waste time subpoenaing those witnesses.
Okay. All right.
Because that's very helpful to us to wade through the noise.
Now, to be clear, Ms. Nestor, Ms. Lewis, Mr. Ramos, you heard me say it's not going to prejudice the state's right to add, withdraw,
course.
change
Yes,
its
of course.
mind prior to October 31, right?
No, and I think, and Judge, I think the issue has been, it's not that we haven't had him. At no point, and I'm not sure why Mr. Bloodworth would insinuate that we don't have access or that we think he's hiding anything. That is not the case. The point of it is we have a lot of information, which we have been going through, so disagree with that. We're going to trial on a case that I guarantee is not going to take up 11 terabytes of information.
Right.
It will not.
I
Okay.
understand.
And so, but what we wanted to do was to try to get that universe very, very, very small if we could. We understand they have to provide everything to us. I think this is a fantastic solution to it that will make things very clean. So we really appreciate that August 15th deadline, Judge.
Yeah, I'm not inferring any bad faith or lack of diligence on anybody. I think we're just recognizing that the 16A1 disclosure obligation is like this big, and the
Right.
16A5 pretrial exhibit disclosure obligation is like this big. And so this will help get both sides of the V from the big bubble closer to the smaller one that's going to be used at trial.
Yes, sir. Thank you.
Okay. Let me just go around the table one more time. Mr. Bloodworth, anything else today? Ms. Shervanek?
No, Your Honor.
Mr. Burmester?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Ms. Nestor?
Yes, sir.
Mr. Ramos?
It's almost 5. I'm
All right, very good. December 5. What time did I say? 3:30? 3:30 p.m. by WebEx. I wish you and your clients and your families the very best. If anything emergency comes up, please let me know. We will contact Ms. Young, Summit County, to determine the terms of the conflict contract and figure out what's possible in terms of appointment of counsel on the newly filed case. We'll schedule an initial appearance and send out notice. I wish you all the very best. Please take care.
Thank you.
Thank you.